in tight, can you see it? Streaming the truth live from where they decree it. Sylvia speaks, no filter, no buffer. Courtroom drama couldn't get any tougher.
When the gavel's first bang, to the witness stands tears. Sylvia's lens captures all your hopes and fears. Uploading justice one trial at a time. Tuning every moment, edges sublime.
Welcome to the Sylvia show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Faces tell stories, the courtroom can't hide. Sylvia's insights cut through the divide. From jury talks to the lawyer's secret. In Sylvia's world, you know you'll need it. Behind the scenes where whispers are loud, her lens reveals the truth in the crowd. Courtroom secrets laid bare to see. Stay curious, may the Sylvia spring. Every objection, every sharp retort, Sylvia's there to give you the report. Exclusive footage no one else can snag. From catchy headlines straight to the tag. Welcome to the Sylvia show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show.
Faces tell.
Can y'all hear me now? Oh. Can you hear me now? Can you hear me now? Can you hear me now? Okay, thank you. Thank you for letting me know ahead of time. If I was looking on another page, I probably wouldn't be able to hear you guys telling me that you can't hear me. I don't know. Every time I move my mic, it kind of disconnects it, and if I'm not looking at the screen, I won't know it's disconnected. But hello, everybody. I was complaining about Kobe again because Kobe over here making noise. I'm babysitting, and because he'll make noise while she's working, and so he's in here now making noise in here. Kobe just likes to just get under my skin. But anyway, I wanted to bring to you guys attention because tomorrow Ernest Williams goes to court on his charges. I wanted to what's going on, but my dog has been whining so bad that he never does that. Kobe, okay, see y'all, okay, let me just put this little thing in here. Kobe is a Shih Tzu, right? And they said Shih Tzus have anal gland issues, right? So this past weekend, his burst at the doctor's office. And so the doctor gave him some antibiotic and some painkillers, right? So, and they told my daughter, not to allow him to lick his, behind. So she has a cone on his neck, or sometimes she'll put Pampers on him, dog Pampers. So he can't stand that stuff. So he whines. He's whining like crazy because he wants the pamper off or he wants the cone off his head. So, I mean, around his neck. So that's what his problem is right now. She has him in here as me as the babysitter, and that is what's going on. Okay. So that's Kobe's issue. Enough of Kobe. Let's go ahead on and bring up what I want to talk to you guys about. Today is a day before Ernest Williams' final plea calendar, which during final plea is when it's right before the actual trial starts, or when they set the trial to start next. It's where they cover everything that needs to be covered. Is either whether the defendant wants to take a plea deal or not. You know, it's just to tie up all loose ends before trial starts. Okay. There's a few things I want to bring to you guys' attention in regard to Ernest Williams' case, and something that when I was watching Mr. Bernie's cases, I realized that's the same thing they're doing with Ernest's case. He has 3 open cases. He has, well, 1 actual indicted open case and 2 non-indicted cases. Okay. And I want to show you something that I'm gonna give you guys my prediction, and then you guys could figure out. It's nothing that I personally know. This is my perception and my prediction and my thought pattern. It has nothing. No, I don't have any kind of inside information or anything like that. I'm just giving you guys from my personal views of what's going on in the case. Okay. My personal views. It's nothing that's been given to me, you know, contrary to what people believe. There's nothing that I personally know other than what everybody knows. Everything else is just guessing, okay? Make an assumption, which you know what they say, when you assume something, you make a blank, blank, blank out of you, blank, 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 and blank, 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 okay? So this is all alleged from my perception, okay, of the case. But there's some information that I will share with you guys in regard to me being in Fulton County, the things that's going on in that courtroom, and which will base my assumption on, since the informations that, you know, that Mr. McBurney talks about, Judge McBurney, I'm sorry, not Mr. Judge McBurney talks about. Well, today I was watching one of his cases, and this guy was there for a revocation of his bond. And during the time when he was out on bond, this guy has caught a couple of new cases. This guy has an addiction, substance addiction, and he robbed, did some things that, you know, to feed his addiction. So he caught a couple of cases. So the case that he caught had to do with some sort of robbery. So they brought him in to revoke his probation for the case that he's just being charged. And then they found out that he had additional cases. Okay. One of those cases with Judge Shamika Williams, which is, you're pretty much familiar with her. She's the one who has Mr. Gregory King case. You know, the one that has all this other cases that we know about, right? The one that we heard has some sort of judicial misconduct cases against her, that judge. Well, she has one case and another judge has another case. I didn't hear the other judge's name, but I heard her name. So what's happening now is McBurney said to the counsel of Mr. whatever guy, I don't know the guy's name. He told her, the attorney, that what the court is doing now, anybody that has other cases that has been indicted, hasn't been indicted, cases that's still open cases, they're trying to consolidate all of it to one judge. One judge, whichever judge is the current judge on that particular case, they're going to take all other cases that this person has and bring it all to one judge. So they're consolidating those cases. So with that information being given, we all know Mr. Ernest Williams has 2 cases that has not been indicted. You know, the CP case, remember the CP case back in God knows when, and the SA case that has not been indicted as well. Okay, so those 2 cases are now going to be consolidated under Judge Hathaway. That's his name, Holloway. Hold on, let me get the judge's name. I don't want to mess up the judge's name. Hold on, let me go in. Okay, hold on. Hold on. Let me go in and pull it up. Sorry, y'all. I gotta sign in. Hold on a second. I gotta bring it up. Because I was in here for so long, it kicked me out after a while. Hold on. All right, let me bring this up to you guys so you guys can see what I'm talking about. Hey, thanks, Felicia. Reminder of your membership. Thank you for being a member for 22 months. Okay, Felicia, you've been with me a long time. All right. Okay, this is Ernest Williams cases, right? This is that the CP case, original one, is closed now, right? And then he has those other cases. Those one was with Judge Adams, and that was the not Judge Adams, Belinda Edwards. These 2 was with Judge Belinda Edwards. Those were the cases that he had for theft by taking, and also the credit repair case. Well, those are 2 cases he had, which they closed those cases, but now they're part of this case right here, which is the RICO case. They have a whole bunch of different things added on there. But I noticed they did not add the CP case, and they did not add the SA case in this one. Because RICO, remember a RICO case, you can add anything. You could add everything and the kitchen sink in RICO case. So this is a case that's open. CP mean as it's in superior court, and this actually has been indicted. Okay. These are pre-indictment. PI mean pre-indictment, and this is a criminal complaint right here, which is just a complaint. It has not been indicted. It hasn't been taken to grand jury. The only thing it says there's some sort of probable cause. Okay. So these 3 cases right now are open cases. Guys, you can see that? Can you see that? See, there's 3 open cases. You guys see it? Okay. So now, here's what I wanted to bring to you guys' attention. This case right here, and this case right here, you will see that Mr. Hoover is now added on to his case, meaning that most likely it's going to be consolidated. So now you see right here, you're going to see the attorney, Hoover, right? You see him as the attorney. He was not the attorney before. He just became the attorney as of March the 20. Let me tell you exactly what date is on here that he came on. Hold on. Which is this year. Hold on. And you can see it from the other with the other website, but you can't see it on this one. I'm sorry. But at the court, you could see what day he came on as a retained attorney. Okay. So you can see this is the aggravated battery, the rape, and all that. And these are still not indicted cases. They have not gone to the grand jury. They have not been indicted. Okay. It's still pre-indictment. You see that, right? They said they filed it back in 2023. It's almost 2 years, and this case has not been pre-indicted. Okay? And it's still considered a criminal complaint. CP mean criminal complaint file. All right. All right. So, and there is no judge assigned to this as of right now. But because Mr. Hoover has now been added on as the attorney on record, most likely that case will be talked about tomorrow. It's my assumption. I don't have a concrete evidence of that, but this case is most likely is going to be talked about on tomorrow. In this case as well, this PI is pre-indictment as well. You see this one says pre-indictment, and it's an open file, and it was re-indicted because remember originally it was back in July 2023, but they re-indicted. I mean, they reset it, not re-indict. They reset it. They did a non-process on the other one, and then they redid it, and it still has not been indicted. And you see Hoover now is the attorney on there. Okay. And this was supposed to be done in 2022. Okay, this is the CP charges. They still have not been indicted. Okay, let me go back and bring that back up. Let me bring this up. Let me go back. I know this by heart. I know he's number 3, third page, and he's down here. All right, so now we're going on to this actual one, which was indicted. And this one is the one they have as the RICO charge. And you see Dunaway is the judge's name. Dunaway, I say Hathaway, Lord have mercy. But Dunaway is the judge on this, okay? And you see and there you see Hoover right here now as the attorney. Okay. And now you see with the RICO, you see how they added everything that's on there. They put violation of RICO. They put false swearing, filing false document, bigamy, theft by taking, theft by taking. This is the 2 cases. Remember I was telling you about the theft by taking and the credit card thing? That's all part of it. Conspiracy to commit a misdemeanor. You see there's, and you see the dates on these things here, right? You see the dates are like old dates. But with the RICO, you can bring up stuff that's past the statute of limitations. Because you got something from 2014. See? 2014, that's way past statute of limitation on these things. But because it's a RICO, they can bring everything and the kitchen sink on a RICO. But you notice they have not put in the CP and they have not put in the SA. Why they haven't done that? Your guess is good as mine. I don't know. I don't know why they haven't put those in there. When this, because he has 40 counts on here, 40 charges. And why would you not put in the CP on there? Don't know. And all these cases here, they were never actually indicted on these cases before. So why not put the CP in there as well? It's kind of strange to me. Donnie, Lucy, I was thinking about Donnie Hathaway. I probably was. So here's my prediction for tomorrow. Here's my prediction. And look, and this one here, conspiracy to commit a felony, that was not presented to the grand jury. But these thing up here was presented to the grand jury. Except this one right here. This one was not presented to the grand jury. But everything else was presented. Okay? And they have his co-defendant as Erica Hughley. And Erica King is her name as well. And then you see Over here is going to be the final plea. Hold on a second. All right, so my thought on this case, my prediction. Well, I'm not going to give my prediction. I'm going to leave it alone. I'm not going to give my prediction. Because if I give my prediction, folks are going to be like, how you know? I'm just giving you an educated guess. But, so tomorrow is Mr. Ernest Williams' hearing. I will be there in the morning. I will be there to bring you guys what the update is, okay? So, y'all know I was going to be there because, you know, I've been on this case. I was, in fact, one of the first ones. I was the first one in the courtroom, in fact. I was the only one in the courtroom in the beginning, and then everybody else started coming in. And I just stepped away with all the extra drama that was going on. So I stepped away. Lucy, what's my prediction? Lucy, I'm not going to give my prediction. I'm not going to give my prediction. The prediction, whatever it is going to show tomorrow. I'm not going to give my prediction. Okay. Will you be recording? No, Dina. I'm not going to be recording. My mind is more on the Diddy case, getting my mind together for my travel and things like that. So I will not be doing any recording of Ernest Williams' case. I could have, but have no desire of doing that. Thank you. I got somebody just sent me parking for tomorrow. Thank you. Who did this? Is this Miss Richard? Miss Richard, is this you that gave me parking for tomorrow? Miss Richards, is that you? Yep, it's Miss Richard. Thank you, Miss Richard. Thank you. I knew it was you. But you know what? Let me add your name on here because I never added your name on my phone. Hold on, let me add your name. Okay, I just added it. So now when I get it, something for you, I'll know. Okay, I got it. Thank you, Miss Richard. Morning, my prediction. Let me see. She says, my prediction is more than half of those charges won't stand. They have to power up to make half of them stick. D Classic RV, like D Classic. Oh, girl, I needed to. You do RV? Oh, you do RVs? I gotta talk to you. I gotta talk to you. Okay, never mind. Yeah, sorry. Sorry, I get a little bit beside myself. But anyway, she said half of those. Okay, question, y'all. Why is it since 2023, which they said it happened in 2022, those SA charges, right? And the CP charges, why haven't those been indicted yet? Can somebody help me on that one? Why haven't those been indicted? Why haven't they brought it over to the grand jury? Wouldn't you think that would have been something they put in grand jury? Because that's what's holding him from not getting a lower bond. No, you understand what I'm saying? Okay. You holding him because of those horrible charges. Those are terrible charges, right? Why have they not indicted him on those? You indicted him on all the crazy stuff. Why haven't they indicted? That's something you probably need to question. You know, you charge him with a RICO. A RICO, you can put everything and the kitchen sink inside of a RICO. Everything. Why not charge him with, put that as part of the RICO on those two charges? Those are horrible charges. Do y'all understand what I'm saying? Isn't that something get you to say, sorry, I was talking in the phone, but y'all get the point? Yeah, we do. Dina, come on, just come on, y'all. Let's just think about it, right? These horrible charges, these are terrible. You know, crime against children, crime against women are terrible, terrible, terrible charges, right? These are the charges where they said the person is a danger to the community. They will not let them out. But hey, I got something else for you guys. Hold on. I got something else for y'all. Just recently, there was a church in Roswell where this pastor, he is just recently charged with child P. Okay? More than the number that Ernesto's supposedly claimed to have. More, okay? Ernesto's bond came down to $700,000, right? His bond, total bonds over almost $2 million. Now, just listen, y'all, listen. Do you believe this guy just got bond? The charges just came about 2 weeks ago. He got bond already. And he has way more CP charges. He was a minister of the children child church, the children's church. He's on bond, y'all. He's on bond. And he's on Fulton County as Roswell Church. And he has way more charges. And guess what his bond is? Guess what his bond is? Can somebody guess what his bond is? He's on bond. He's out on bond right now. Guess what his bond is? Can somebody guess? No, not that cheap. CMT, not that cheap. Not that cheap. Not that cheap. She said $1,000. Not that. No, somebody said $1. No, his bond is $100,000, y'all. $100,000 for his bond. Yes, thank you. Love to shop. Yes, it's $100,000. It's $100,000 for his bond. $100,000, and he was the minister of the children's church. You said you think it's because of Ernesto's past conviction, even though it has passed CP and grape conviction? No, but CP and grape conviction are the reason why he could not get bond in the beginning. Remember? They said no bond. They refused to give him bond. Judge Adam, Kimberly Edmund Adams, refused to give him bond because they said he was a risk to the community. So that's why he did not get bond. So Lucy, you're right. It's probably his past history, right? You're probably right. Because he's like a repeated offender type of thing. Yeah, I can get that. Yeah. But the other guy got, what's the guy's race? Come on now, you know the man's race. Come on. He's not black. He's not black. He's not black. He's not black at all. If he was married to nobody, he would have bond. Yeah, you're right. You're right, D Classic. Yeah, you're right. So, but you know what? I don't think race has to do it because the DA is black, right? The DA's office got majority of black. So the DA office is majority of black, okay? 80% of DA office is black. Maybe because he has an active court case going on. Maybe they're waiting to indict him on other charges. I don't know. I can't make it make sense. They didn't they have name didn't they just name a street after her too? She's probably the besties with Fonnie. You talking about Shirley Franklin? His past, and they said he was a flight risk. Remember, he had means and access when he first went to jail. That's true, but does he have means and access now? He ain't got a dime. Why is Will Wooten only prosecuting one case when there is such a backlog? That is a good question. That is a good question. What we probably need to go do is look and see if what cases he has. Because you can go to Fulton County and type up the attorney's name and see how many cases that attorney has right now. Let's go do that for a second. Let's see. Let's see if Mr. Wooten have other cases. Hold on. Let's see. Let's see if something pops up with his name on it. Let's see. This thing keep kicking me out. I got to keep signing back in. Hold on. This website's silly. I got to keep popping back in here. No, it's only pulling up. No, it just pull up judges. It doesn't pull up. Not on here. If I was at Fulton County, I'd be able to pull up the attorneys. But on this here, they don't let you. They don't let you search. They don't let you search by. Nope. You could search by the judge. You could search by court date, case type, but not here. She said, City of Atlanta is just so corrupt, and I am a Grady baby. They disgust me. Are you still in Atlanta? Are you still in Atlanta? D-Classic, or are you in your RV riding around? Okay. Now, shall we move on to Diddy's stuff now? Are you guys finished with Ernesto with me? She said, why? Oh, okay. CMT says, curious. I'm getting tongue-tied here. Why Wooten is being subpoenaed by the Senate committee? That's a very good question. But has he showed up? Has he showed up to the Senate committee yet? He ducking it. Not yet. They ducking and dodging because he's busy working Nesto. Guess. But Yes, RV Park, Covington. I have a house in stuff. You over here. Okay, D Classics. Okay, you over here. Okay, RV Park and Covington. I know where that is. I know where that park is. All right, let's go ahead. Let's move on to our next topic. All right. Last night after I went to bed, I woke up this morning and I saw new stuff on Diddy's case. They are going back and forth, back and forth. One person says one thing, another person says another thing, and they're going back and forth, back and forth, back and forth. Well, I want to give you guys the latest back and forth between the government and between the defense. So they're going like, and you know how it is. You know how it is. When you feel that you want to fight, you're going to fight the hardest, right? All right, so let's go ahead on and let me put my little dandy little thing up here. All right, I'm putting my little, my little overlay. Let me go ahead on and let me show you what the okay, remember the last person spoke was the state. Now we're going to go to the defense. The defense says something, and then we're going to go with what the state says. Okay, this is the defense replying to the government from yesterday. Okay, this is what they said. All right. This is to the judge. I'm not going to mess up the judge name because y'all know me and my Ebonic self. I mess up with the name, so I'm just going to say Judge S, okay? All right. And anybody's name who I feel I'm going to screw up, I'm just going to say the letter of their name, okay? To avoid any kind of folks saying, oh, she can't read. She can't read. All right. And remember, all right, hold on a second. I got something going on. Hold on. Kobe is harassing me, y'all. Kobe is harassing me. Can y'all see this? Can somebody tell me if they can see what's here? Should I remove myself and y'all just go ahead and look at the paperwork itself? Y'all rather have it like this? Let me know. Y'all, let me get a throat cough drop because my throat's starting to itch again. Hold on. You know me and my allergies. It's that season. All right, here we go. I had to put a cough drop in my mouth because my throat is itching. Ha, I caught myself. My thing came out because I hit the table. And I saw me not having the ability to talk. But hold on a second. Let me let this thing work in my throat a little bit because it's itching. All right, here we go. Dear Judge S, we write on behalf of Sean Combs. To respond to the government's post-argument reply dated April 23rd, 2025. Kobe, stop. My God. In which the government, among other things, urged the court to admit Dr. Hughes' opinion regarding coping strategies and to request that the court reconsider its April 25th, 2025 ruling as to that portion of Hughes' proffered opinion. Hughes' testimony on coping strategies is not admissible under Rule 702 because it will not help the jury determine the truth as to any issues in this case or explain any matters beyond the jury's ken. Instead, Hughes will make obvious points. Basically, some people do this, some people do that, without any semblance of scientific precision. No similar testimony on coping strategies was discussed or admitted in either case. In either case, the court referenced in its April 25th ruling as supporting the admission of Hughes's testimony on delayed disclosure and memory. United States versus Ray, 2022. United States versus Young. The government's renewed request to open the gate to such testimony will merely allow prosecutors to cast their preferred fact pattern in a jargon-heavy, pseudo-scientific veneer, and then argue that Combs is guilty because the alleged victim acted consistently with Hughes's opinion. Jurors don't need this. Fairness counsels against it, and the rule of evidence do not permit it. For example, the government expects several alleged victims to testify that they consume narcotic to minimize the emotional, physical, and psychological pain of participating in FOs, which is freak-offs. Government Letter 1-2. Hughes will bolster this testimony by explaining that victims may seek to numb and minimize painful sexual and abusive experience through the use of substances, such as drugs and alcohol. Hughes' disclosure 4. No juror capable of finding their way to 500 Pearl Street needs an expert to explain that some people consume alcohol to numb painful experiences, including painful sexual experiences. Jurors also understand that some people who enjoy partying use substance for pleasure, and that others may do so because they have long-term habits. Having an expert explain these basic facts of life adds nothing useful to the trial record. Similar, the jury doesn't need Hughes to explain that commonly victims experience a sense of mental defeat upon realizing they are unable to prevent the abuse or its continuation and escalation. ID. None of this makes any fact in the case more or less likely. Instead, it just gives the juror buzzword for everyday experiences that require no expert exploitation, while allowing the jurors to equate lack of action with victimhood and hence with the alleged perpetrator's guilt. These opinions, supposedly neutral, but in reality giving the government a pseudoscientific basis for what would ordinarily be jury argument, fail both Rule 702 and Rule 403, which plays a uniquely important role in a district court scrutiny of expert testimony, given the unique weight such evidence may have in just jury deliberation. Namely, versus City of New York, the 2005 case. Similarly, inappropriate is Hughes's opinion that victims often fall back on ingrained responses to power in order to stay safe, such as attempting to please or place it the abuser, bargaining with the predator, complacent with demands and expectation, and or remaining silent. ID. Hearing Hughes's opinion on this point adds nothing to the jury's store of relevant information. It's just put a thumb on the scale. It suggests that anyone who tries to please or place it a romantic partner and submit to another's expectation may have been abused. It improperly promotes an image of victimhood as the context through which the jury should filter the evidence. I'm sorry. I went through the same thing. Let me go to the next one. Hold on. Equally is not even more problematic is Hughes's opinion that while most victims use some form of verbal response to communicate non-consent, certain common behavioral responses such as engaging in polite resistance and attempts to persuade, deflect, or convince the predator to stop may communicate lack of consent. ID. These opinions confuse the issues and will mislead the jury. The issue in this case is coercion, but Hughes's injection of consent, a classic legal term which has branched into many aspects of popular culture, is liable to confuse the juror about the legal standards to be applied. Indeed, during a recent meet and Comfort, the government expressed plans to move to preclude the defense from posing questions about consent to witnesses, taking the position that the word would mislead jury. The jury will be instructed on coercion and should apply those instructions and those instructions alone to determine whether the victim will was overborne. At the April 18, 2025 conference, the court expressed skepticism about Hughes's proposed testimony concerning coping strategies. Trial transcript 27 through 30. The skepticism was well-founded. Hughes's general testimony on coping strategies is not admissible expert opinion and should be excluded. That is her response to the government. And then the government replied back. Let me go to the next one. Stop. Okay, we're going to close this one out. All right, we're going to open up this one. This is the government replying to the state. Hold on. That's the government replying to the defense right now. All right. Dear Judge S., during the court conference on Friday, April 25th, defense counsel raised a concern that the government was adding racketeering act in an enterprise letter that were not voted by the grand jury. The defense argued that if the government was seeking to try Mr. Combs as acts not founded by the grand jury, this would violate his Fifth Amendment right to grand jury indictment. The court inquired as to the precedent that would fit counsel's argument. Counsel responded that we would submit a short letter addressing the court's inquiry on this sole point. Although we have not identified authority focus on the precise fact here, the Second Circuit's decision, United States versus Bassinio, cited that our April 23rd, 2025 letter generally supported the proposition that the government cannot add to or change the pattern of racketeering activity voted by the grand jury. The court stated that pattern is an essential element of racketeering. Once a grand jury has charged a pattern racketeering common to a number of defendants, only the grand jury, not the court, may decide whether an individual defendant should be charged with a different pattern after a co-defendant plead guilty. ID 206. Our concern is with the government substituting a different pattern of racketeering for the pattern charged by the grand jury. ID. By adding act in the enterprise letter not found by the grand jury, the government has violated the holding in Bassiciano. Assuming the government is permitted to argue that the grand jury may convict based on racketeering act not presented to the grand jury, we reserve the right to raise the issue again, either in the Federal Rule of Criminal Procedure 29 context or in connection with the charges conference. We appreciate the court's consideration. Submitted by Mark. All right. Now there's the defense response to the government. Do I have any more? Nope. No more. So that is what they are arguing over. Let me see if they have anything that is new. Hold on a second. Let's see. Let's see if they have anything that is new. Hold on, y'all. Let's see if they have come up with anything new today. Hold on, y'all. Let's see if anything new came in today. Let's see. No, nothing new so far. I just pulled up the newest document for Diddy's. I know someone was saying that there was something having it where they said that he had some sort of mental I didn't pull that up. Maybe I should pull that one up. They filed a lot of sealed documents in here. A lot of sealed documents are here. Did we talk about the charge? The request for charge? Did we talk about it? I know I pulled up the paperwork on that, but I don't know if we ever talked about it. We talked about the voir dire. Okay, let's see. Let me see. I know this is like the wrong time. I got some ginger chew classic. I have some ginger chew. I have those too. I have those, but I was using a cough drop because you see how easy that one it went for me. But ginger, some strange reason it don't be working too well. And I try to drink my water. Got another bottle ready to go. I had 3 bottles here. And I just finished this bottle. Yeah, I just saw me finish this bottle. And then I had some Diet lemonade. I be drinking my fluid. I had the diet lemonade. I had to wash that off. Chick-fil-A. Did you ever try the dragon fruit Chick-fil-A? Diet lemonade. So I've been getting my fluids down. Hey, Mel. Hey, Miss Jam. I know everybody's watching Karen Heard case, and I know that's a very exciting case. That's where most folks are. But I'm gonna wait for that verdict on that case. I'm gonna take my butt on down to the courthouse. Not here. I'm gonna go. I mean, not Fulton. I'm gonna go down here because there's a case I'm looking at over here. Yeah. Oh gosh, I got an itchy owie. Okay, I gotta get off this live now. If anything comes up, I will come back with you guys. Is Rosie in here? Is he sleeping? You know, one thing I'm gonna be appreciative of going back to New York. I won't have to deal with all of this pollen stuff. I won't have to be dealing with all this pollen stuff. What is happening right now? LOL. What do you mean what's happening right now? I gotta What do you mean what's happening right now? Look at me on steel. Look at me in steel, y'all. We used to take pictures all the time. Those are the good old days. Oh, you know I always get some intel. Hold on a second. Let me get my phone. Hold on. Getting a secret. Good morning, everybody. Those that are coming in right now. I got some How many of you guys think that Ernest is going to take a plea deal tomorrow? How do you guys think that Ernest is going to take a plea deal tomorrow? How many people in the chat? That should be let me pose this question. First, I'm going to pose it to the ones in the, let me pose it to Infamous channel first. And then next, I'm going to pose it to the, all right, here's start voting, y'all. I want to see what you guys say. This is in the Infamous Sylvia channel side. How many people think he will take a plea deal tomorrow? Yes or no? Voting time for the Infamous side. Oh, all of you guys, okay. 5 votes, okay. 6 votes. 67 says yes, 33 says no. 6 votes. Come on, guys. More people in this chat. It's 28 of you guys in here. It's 7 people in here. I mean, 28 folks in here. It's only 7 votes. Come on, y'all, vote. Y'all scared to vote? Are you guys scared to vote? I'm going to go over let me go to the other side and see what these other people say with the votes. Hold on. Let me go to the other side. Let me see what you guys say. Let me see what you guys saying over here. Let's see if you guys vote and what your vote would be. All right, here's the voting. All right, let's see. Let me see what you guys say. %64% in the Infamous channel says yes, he will take a plea. And how many on the 56? Okay, more of the people in Infamous side think he'll take a plea. Now it's 50-50 with the Slide channel. Slide channel is 50-50. Wow, and there's 10 of you guys that voted. 10. So that means 5 said yes and 5 said no. Can we get a tiebreaker over here? Okay, 55% said no. He won't take a plea tomorrow. 58% says no. Okay. Okay, 62% on the Infamous Slide channel says that he will not take a plea. And on the Infamous channel, 64 said yes, he will take a plea. And there's 14 votes on that channel. Okay. So it's 64 opposite and 64. So y'all gonna break the tie or what? It's 14 votes on both sides. Y'all gonna break the tie? So on the Infamous Slide channel, we have 64 says that he will not take a plea. And then on the Infamous channel, it says here that 67% says yes, he will take a plea. We will see who wins tomorrow. We will see who wins tomorrow. %69 said he will take a plea. Okay. The other one says 62%. And that's 16 vote. How many votes on this one? 16. Okay, y'all got numbers neck and neck. Why y'all not voting, the other folks? Why y'all scared to vote? The Infamous have more votes than the other ones. Got 17 people voted on the Infamous. We got 16 people on the Slide channel. Why y'all scared to vote? You know, you said the question, are they gonna? No, they offer, every single person in that courtroom has gotten plea deal offers. That beautiful chocolate, they gave him a plea deal. They absolutely did. They offered him a plea deal. Absolutely did. Now, do they take it? That's another question. They absolutely offer them a plea deal. Because they rather not have to go to trial. And yeah, they can always plea out anytime during the trial as well. They always offer them a plea deal. Look at Diddy. They offered Diddy a plea deal. It's just that half the time they don't ever put it out there, because half the time people be like, no, let me go to court. Let me go to trial. Oh, there's something just posted right now. Okay, hold on. Diddy's thing just posted just now. Hold on, y'all. Something just posted on Diddy's case. Hold on. Hold on. Hold on, y'all. There's a motion. Hold on. Gotta move on. Gotta move down. Hold on a second. Hold on a second. Let me go back up here. Pacers login. Gotta get my Pacers login. Hold on. Hold on, I'm trying to get my login for my Pacers. Hold on. Trying to get my Pacers login. Hold on. You know, you have so many passwords for so many different things, and I'm trying to get the right password for my Pacers login. Hold on. Pacers. There it goes. Got it. Oh, I don't want the Eastern District. I want the Southern District. Why my password's not working? Password's not working, y'all. I have to reset my password. Lord have mercy. Hold on, y'all. Just a second. Lord have mercy. Here we go. I gotta reset my password. Okay. Okay. I successfully changed my password. Let's go in here and correct that. Okay, so let's sign in again. And let me put my password. All right, here we go. Let's go. Now I'm in there. Okay. No, I don't want to go. I want to go into the main thing here. Okay, here we go. I need to go to the Southern District of New York. Southern District of New York. Southern District of New York. There we go. Now, okay, I have agreed. And now we're going in. Now we're going into the query. We put the case number. What's the case number? Let me go get the case number. Let's go get the case number here. Case number is 124 SES. Copy. Let's go into case number. All right, we got the case number right here. We're going to find the case and we're going to go run the query. Combs. Okay, let's go to. Here we go. Let's go into docket query. All right, here we go. Okay, the judge submitted an order, y'all. Okay. The letter in motion. Okay, let's see what the judge ordered. All right. A pretrial conference to resolve the dispute over jury questionnaire. Response will be held on May 1st at 1 p.m. in courtroom 26A. All right, so that's the order for today. You guys, let me show y'all. Hold on. All right, this is the order for today. The judge just made this order just now, okay? Okay, this is what the judge submitted just today. So that is on Friday, right? That's tomorrow? No, tomorrow's the 3rd. On Thursday. That's Thursday, y'all. So Thursday, the judge wants them to have a hearing. So we will be going live here to give you guys an update on that. So put that on your calendar because they're going to be arguing over the stuff that we just talked about. But hold on. Let me show you what else they're going to argue about. Let me show you what else they're going to be arguing about. All right. There we go. There is a letter of motion today. And this here right here. All right, this is what they're arguing here about. We're going to talk about this right now, okay? All right. Let's go ahead on and talk about this. All right, let's go ahead on. Let me what do you think about the current Tyree Nichols trials? The currently going on. Who's Tyree Nichols? I don't even know anything about that. Will you be covered into? I have no idea what that case is about. Good morning, beautiful chocolate. Good morning. All right, so let's go ahead on and share the letter. Okay, y'all ready? Let me go ahead on and put my little dandy little thing up. because, folks be trying to take your stuff. You know what I'm saying? Okay, let me move out the way so you guys can see this motion that was submitted, because there's some arguments that the judge needs to handle on all this stuff here. All right, let's go ahead on and handle this. All right, and that's April 28th, which was yesterday. Let's see who this is by. Hold on, let's see who wrote this letter. Hold on. Oh, this is Diddy's attorneys wrote this out. Okay. Okay, this is Diddy's attorneys put this. Okay. All right, Judge S. We write pursuant to Local Rule 23.1H and the 5th and 6th Amendment for an order prohibiting extrajudicial statement from anticipated witnesses, lawyers, until the conclusion of trial. So they're putting they're trying to put a gag order on those, the attorneys, y'all. Okay, this is the attorneys for the witnesses, so they can't talk. In light of the unprecedented amount of publicity and recent prejudicial statement by counsel for government witnesses, an order prohibiting such statement for the limited duration of the criminal trial is narrowly tailored to protect Mr. Combs' constitutional right without unduly infringing on anyone's Fifth Amendment rights. Okay. All right. It ain't playing with them. As the court is aware, Mr. Combs previously moved from a gag order of prospective witnesses and their counsel to mitigate the onslaught of negative publicity preempting the jury pool, and the court indicted its openness to other tailored proposals that will help ensure a fair trial. ECF 63 at 4. Since then, witnesses and their counsel has continued to make numerous statements to the media, including by previewing their trial testimony in widely distributed documentary and commenting on the criminal procedure to media outlets. Absent a court order, we expect the publicity to not only continue, but escalate as trial commences. Indeed, in recent weeks, lawyers for government witnesses have commented on pretrial litigation and continue to broadcast prejudicial statements. For example, on March 13, 2025, Douglas Wigdor, counsel for alleged victim 1, made press statement in response to certain of Combs' legal argument, telling media outlet, "It's not surprising Diddy would make a disingenuous argument to exclude the distributing video from being shown to the jury in the upcoming trial." Cassie's lawyer, they told who victim 1 is. They just told who's victim 1 lawyer is. Wait a minute. Well, so far for witnesses. Well, we know who victim 1 is now. If we didn't know, we know now. If we didn't know, we know now. Okay. Cassie's lawyer calls Diddy claim the beating tape was doctored BS. March 13th, 2025. And it was on TMZ. Let's go look at it. Hold on, y'all. Let's go look at it. Hold on. Hold on. Let me show y'all. Hold on, y'all. Y'all see it? Y'all see it right there? Diddy claims are total BS. We think the Cassie video will be admitted. Look. Oh God. Okay, hold on. We're not gonna play this stuff, but this is it right here. It says here, 2016 surveillance video obtained by CNN shows Sean Diddy Combs violently grabbed, shoved, dragged, and kicked his then girlfriend Cassie Ventura during an altercation in a hotel in California. There it is right now. You know, everybody have seen that video all over the place. It go TMZ. And okay, so we already know who victim one is now. All right, let's go back. All right, let's put our thing back up again. Okay, we got that one. Okay. And then now it says here, he also told the media that Combs will be held accountable for his depravity after CNN is accused of altering Diddy's assault video. Cassie's attorney responds. Okay, this is another one. Black Enterprise, Cassie's attorney responds. Okay, let's go in here and look at it. There it is right here, y'all. Cassie's, after CNN accused of altering Diddy's assaulted video, Cassie's attorney responds. And this is his response right here. Okay, this is his response. And we're not going to play it. We're just going to, just so you guys know where it's at. You know what? Let me copy and paste it and put it in the chat for you guys. So you guys can go take a look of it yourself. Okay. Let me copy and paste these things into the chat for y'all. Hold on. Let me copy and paste it into the chat if you guys want to go look at it for yourself. Okay. This is just in case you guys want to go look for it yourself. Here it is right here into the chat. There it is. You guys can go and take a look for yourself. And let me go get the other one so you guys can go take a look for yourself. Okay, hold on. Why my thing just not showing no more? Oh, okay, there we go. So now we're going to get that one too. I'm going to get this one so you can have it for yourself. I'm going to copy. And I'm going to place it in the chat for you guys. Just in case you want to take a moment to take a look at it for yourself. There it is right here. All right. Okay. So, all right. So let's go ahead and make this bigger. Let me go back down. And they got a couple more. Okay. The statements were widely distributed across numerous outlets and social media. As an attorney representing the government's star witness, Mr. Vigdor's Vigdor's comments are unfairly damaging as they give the misimpression to the public and potential jurors that his opinion carries authoritative weight rather than simple one-sided advocacy for his self-interested client. Mr. Combs also recently learned that Lisa Bloom, counsel for another government witness, has been interviewed for yet another documentary that is scheduled to air on the BBC this evening. Ooh, Miss Bloom has previously made numerous sensationalist accusations and was interviewed in connection with the Peacock documentary, The Fall of Diddy. CEG, and then as a YouTube. Let's go look at that one. Hold Hold on, let's go. Ooh, can we click that one too? Hold on. Let's click that one. Let's see what it says.
Check this out. I'm going to show.
Oh, hold on. Let me change my what's the name? Let me switch it. Hold on. Let me switch it to my non-commercial channel. Hold on. Because we don't want
a lawyer representing.
Okay, there it is right here. Let's go see. I don't want to look at it all the way. There she go, y'all. There she go. Hold on.
Some of his employees.
Hold on, let's go. I don't want to play it. Hold on. Okay, there we go. There go Lisa Bloom right here, y'all. There she go. Talking on the interview. There she go. You guys want us to go see that? Let me put that in the chat for y'all so you can go take a look at that for yourself. So you can guys go look at it for yourself. There we go, right here. Wow, it says a case where 5 cops in Memphis, Tennessee brutally beat a 29-year-old black man to death and being streamed live. Oh, wow. Thank you, Rodell, for that. So Lisa Bloom right here doing that. So you guys can go ahead on and go take a look at it if you want to see the interview that she did and that they're talking about, okay? All right, so all right, then he also says, hold on. They're not playing with them, y'all. Okay, hold on. Ms. Bloom, okay, we got that. Okay. Speculating that the accusation are only the tip of the iceberg, with hundreds of people with similar allegation. And then they give that one too. You can only imagine what it did behind closed door. Oh, let's go see what this one is. Hold on. Let's go.
This morning, media.
Uh-oh. Lisa Bloom again. Ex-Kane member of lawsuit against Diddy discussed the case. Okay, we're gonna put this in the chat for y'all. Go take a look at this one too. We're not going to watch it over here. I'm just providing you guys the information so you guys can go and take a look at it for yourself, okay? There we go, right there. All right, so that is that. Okay, let's go back. Those are the 2 videos I just showed you guys. Okay. And it says, speculating and commenting the credibility of Mr. Combs and his client and comparing Mr. Combs to Jeffrey Epstein. Counsel for Mr. Combs previously sent Ms. Bloom a cease and desist letter and have repeatedly reminded her of her ethical obligation and Local Rule 23.1. As the court is aware, Rule 23.1H provide that the court may issue a special order governing matters such as extrajudicial statements by parties and witnesses likely to interfere with the rights of the accused to a fair trial by an impartial jury, and that in determining whether to impose such a special order, the court must consider whether the order will be necessary to ensure an impartial jury and must find that other less extreme available remedies singly and collectively are not feasible or would not effectively mitigate the pretrial publicity and bring about a fair trial. Available alternative remedy includes change of venue, postponing the trial, a searching voir dire, empathetic jury instruction, and sequestration of jurors. Now that the trial witnesses have been identified, and trial is imminent, and a narrow order restricting the statement of counsel for anticipated witnesses for the duration of the trial appropriately balances the constitutional interests at stake. And there are no other remedies that could effectively mitigate the pretrial publicity. For instance, change of venue would do nothing to cure the amount of global press attention. And the other potential alternative remedy suggests in Rule 23.1 a searching voir dire, empathetic jury instruction, and sequestration of jurors can only do so far to mitigate such prejudicial statement. Indeed, if such remedy were sufficient, there would be little reason to restrict extrajudicial statement in the first place. The reason stated herein and in Mr. Combs' early application, EFC number 42 and 40 and 59, the court should prevent further prejudice to his right to a fair trial and direct counsel for all witnesses of the government's witness list, as well as those otherwise working at their direction, to refrain from making public statement for the duration of trial and until a verdict is entered. Respectively submitted, Tony A. and Mark A. And Tenny G. All right, so I'm not gonna mess up people's name. So that is it on them, because I am not trying to screw up folks' names. Not trying to do it. All right, so that is what's happening right now. We just read that. All right, so I am going to take my butt off this live, and I am going to go take care of some personal business now. Is everybody okay now? I'm going to let all the folks go ahead on and watch the trial that they're watching, and enjoy your day. Enjoy your day. Have a great one, everybody. Bye.
Thank you for watching the infamous Sylvia channel, where laughter and fun make up our panel. Together we build this digital spree. We appreciate you and our growing family. With mods by our side and chat flowing free in this online space. It's just you and me. We laugh until tears roll down like the rain. In this virtual world, you ease all my pains. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. We cherish the moments, the highs and lows, from the latest gossip to stories untold. You're more than a viewer, you're part of the crew in this space of ours. It's all because of you. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. We're a family, not just a show. Every click and comment makes us grow. Mods and keeping the vibe so right. Together we shine like stars in the night. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign enjoys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Mars and chat, keeping the vibe so right. Together we shine